Welcome to Case by Case. This is a podcast brought to you by Calum Cheyne and Luke Zadkovich from Zadkovich. Today we've got a special guest with us, Lucy Noble, one of the associates at ZFZ. Welcome, Lucy. Welcome, Calum.
Thank you very much. Happy to be here.
Great to have you back on. How are you, Calum?
I'm good. And we've got a case that's firmly in Lucy's sweet spot, NORs under Voyage charter parties. And it's right in that mix of that good shipping contractual dispute. And there's a lot of interesting facts in this one.
That's true.
A master exercising his discretion to say that a trip is unsafe or proposed berthing is unsafe, and how that interacts with a charter party.
Very interesting. Well, let me open up with the case citation and the names of the parties involved. We are in the London Circuit Commercial Court in England, and this is a matter that was dealt with under the Shorter Trials scheme. Recent decision handed down on the 12th of August 2022. We had His Honour Judge Bird sitting as a judge of the court, and the claimant was CM PMAX 3 Limited, and the defendant was Petroleos del Norte. Involved the vessel, the MT Stena Primorsk. So it's all about a Voyage charter back in 2019. It was good to see a couple of the juniors that we know well on this case. I thought, Calum, we're usually reading decisions which are led by QCs, whereas this one was, fought out by a couple of the leading junior barristers that are well known in the market.
And as with a previous decision where there were some juniors, the judge made a point of thanking counsel for concise submissions in dealing with the claim. Unsurprisingly, it seems like both of them did a very good job getting their points across. And as you say, two counsel we know well that are obviously real stars.
Yeah, and also I liked what came through in the decision was there was a real appreciation of the quantum involved. It was obviously dealt with as a shorter trials case. There was agreement on facts. Don't always see that, but there was agreement on certain facts. There seemed to be a large deal of agreement on what the key issue was. And I think it came through in the decision that the court really appreciated the efficiency by which counsel and the parties involved had approached the matter.
And the experts on either side both seem to have approached it pretty sensibly. You're
right. Well, so flip a coin for who's going to open up on the facts of this one and get us started. Lucy, would you like to lead off?
I would love to. Okay, so we have a Voyage charter party here, as Calum has previously mentioned. We have cargo loaded on board the vessel, and charterers direct the vessel to go to the discharge port. The vessel arrives at anchorage at the discharge port, goes into the berth, and then 12 minutes later heads back out to anchorage, and then stays out at anchorage for a little while before eventually coming in and discharging. And charterers are arguing that this kind of the discretion or the decision made by the master to head back out to the anchorage and then come back in again is something which is either a breach of the charterer's orders under the charter party or is something which stops laytime and demurrage running under the charter party. And so, as it is kind of borne out in the expert evidence to a large extent, the reason that the master did leave the berth was due to the tides at the port. And it was his safety concerns that the vessel would get stuck or get damaged, or that it was just unsafe for the vessel to stay there because of the slow discharge rate that the terminal was advertising. And so I guess the key question there was, or the key factual question was whether the master's decision to leave the berth and then not return to the berth until a later point in time, whether that was whether the safety issue was a valid concern, and how that kind of cuts across all the other obligations in the charter party if it was a valid concern.
There are kind of two occasions where the master didn't follow the charter's orders. The first was he went in, and as you say, he then left 12 minutes later. And we'll come on to the reasons why he left. But then secondly, the charterer said, actually now you have to go back. And he said, no, I'm not going back in. I can't go back in with the full load. And it's a really interesting one because he was, the vessel's draft was right on the threshold for what they could have managed to sail in and out of the berth at. The berth obviously has a depth at which they say this is safe for you to come in and out, and the tide affects that. As the tide comes in and out, obviously there's a certain amount of latitude that you have before you hit the bottom of the berth, and it was right on the fringe of what could be acceptable here.
Yeah, exactly, and it all kind of came down to the owner's guidelines on the underkeel clearance, the EWHC policy. And I thought, I must admit, I don't think I have turned my mind to the UKC so closely on many matters before. Maybe you guys have. It's just a function of the cases. Yeah, and so I thought actually I'd highly recommend this case to any owners out there, crew, or masters particularly, but also the way that owners interact with masters and how to kind of set up the communications between vessel and onshore operators of the ship around this issue of underkeel clearance. But it kind of goes beyond that as well. There's a really interesting dimension to this around the paramount of the master's decisions as to safety, which we know very well that courts will regularly defer to masters on questions of safety. There really needs to be compelling evidence against what a master has decided to do when it comes to questions of safety for the court to rule otherwise. And there was no question when the master decided to come off the first time that was the right thing to do, and the parties all accepted that. It was more the question of, as you say, whether it was the right thing not to come back at a certain point in time. And it was all about the interaction between the owners and the masters over the UKC policy and whether that was reasonable under that policy. It was almost like it was too close to the draft. There was too much kind of uncertainty in there to go ahead. And they after discussion, again, another key point, the owners and the masters talked about it. They decided not to go in, and the court was looking at whether that was a reasonable decision.
They would have gone against the guideline for the under keel clearance, which was 10%, the maximum of 10% of the depth. Let me find the exact wording. Within port limits, fairways, berths, etc., 10% of the deepest navigational draft. So the berth has this kind of set figure for its deepest navigational berth, and the under keel clearance says you have to have 10% of that in addition in order to carry on berthing. And the experts both said if you're going into a berth with less space than you're required by your UKC, then that basically takes away the master's ability to exercise his own discretion. When you're in that realm, you need to go and ask for a particular waiver, that you're allowed to. You could go back to the owners, have a discussion with the owners, say, are you happy for me to go in here? We've looked at the tide, we've looked at the rate of discharge, etc. And the other factor that comes into this is as you're discharging, the ship becomes lighter, obviously. So the amount of space that you need becomes less. And this was the issue the first time that they went into the berth, because he went in, and I think there was an advertised rate of discharge of 10,000 metric tons an hour, I believe. Sorry, 10,000 barrels an hour. And pretty much on arrival, the port said, actually, no, sorry, it's only 5,000 an hour. I'm not sure if those figures are exactly right, but the port basically said, once berthed, the port said, actually, you're not going to be able to discharge as fast as we previously said. So the master did a very quick look at how that would affect the discharging, considered the tide, and said, no, we need to leave now, because now we still have the clearance to do so. So before any hose was attached, he was out. And then with a bit more, go on, Lucy.
I was just going to say, I think it was like a combination of all of those factors that made it quite interesting for me, that these are all the factors that the master is having to consider when making these calls on safety. It's not just the tide. It's not just the weather. It's not just accounting for potential delays, which might happen during the discharge. Like, there's all these kind of variables that need to be taken into account, which I think was quite interesting to read about when looking at the master's decision in hindsight. Well, yes, maybe they could have done so safely, but it was just too great of a risk to bear to come back to the port with all those factors in play.
It's one of those cases where it felt as though the court was always going to be influenced by the evidence of the master, perhaps more than the evidence of the experts. If the master could cogently explain why he had legitimate concerns about berthing, then it's always going to be an uphill battle for a charterer to say, despite those reasonable concerns, we still think that you should have done it. And that seems to be what happened here.
I think that's right. What came through for me in the judgment, in summarising the evidence, was that there was methodology behind the decisions. There were calculations made, as you were saying, Lucy. There were a number of factors at play. Those various factors were being considered. There's the data from them was being put into the calculations. There was then dialogue between master and owners. There was reference to the policy. There was an actual policy in place. The court noted that UKC policies are widely used, and that I thought it was an interesting comment to say they're part of the charter as well. I don't think I had quite kind of got my head around that previously, so I thought that was a really interesting point.
There was a clause, the clause said that the information set out and supplied is complete and correct and an integral part of this charter, and that, I assume, was a clause that the charterers would want to see in the charter party, because they would be saying, we want you to effectively give us a warranty of the ship's performance based on these questions. But actually, in this case, it kind of twisted back around and it became very helpful to the owner. It's like I see big that protection. Yeah.
Should we touch on some of the clauses in the charter, because I think it's worth painting the picture on where delays, rest and fall. In this one. And
so we're looking at a Shell Voice 6 amended, which was the charter in issue here, and the judges obviously pulled out the key provisions. I think the really key ones for me were clause 3.2, which says owners shall adhere to charterer's voyage instructions as long as such orders are considered safe by the master of the ship. So that that's really the big shield that the owners are going to use here. They say the orders weren't considered safe by the master of the ship. And there we go. And then also clause 4, which says that charterers shall exercise due diligence to order the vessel only to ports and berths which are safe for the vessel and where the vessel will always be afloat. And that one, we can probably come to it slightly later on, but there was a counterclaim by charterers for lighterage costs, because ultimately what happened here was the vessel did not berth until some of the cargo had come off it. They had to lighter the vessel before it could berth, and the charterers said, if you're wrong, owners, on your claim, and if you were not entitled to sail away from the berth and reject our instructions to berth, then those lighterage costs are for your account. And secondly, there was a provision in the charter party for half rate demurrage, and there was half rate demurrage in this charter if there was lighterage caused by something that was no fault of either party. And I think that clause there that says that, charters will exercise due diligence to order the vessel only to ports and berths which are safe for the vessel and where the vessel will always be afloat. I think that counted against them when they were looking at when the charters were trying to claim that the demurrage rate should only be half demurrage, because they did in fact order the vessel to a place where the judge found that it couldn't necessarily safely lie afloat.
Yeah, exactly. I think you're right. There are various other clauses as well referenced, but those two clauses, Clause 3.2 and Clause 4, they set up this scenario quite rightly where safety is paramount. That's in the discretion of the master, considered safe by the master of the ship. So owners only need to follow the voyage instructions in that instance. And also there's due diligence obligation on the charterers, as you say, to only order the vessel to ports and berths, which is safe for the vessel, where the vessel will always be afloat. That kind of sets up this scenario where if a vessel like here has to go to a berth where there's a risk or a substantial risk or an appreciable risk that the vessel may touch bottom on at some points in the tide, then the vessel's not always going to be afloat. And that's not a situation where there's lightering or there's a need for lightering because of no fault of any party. That is very much in the scenario of, the ship should not be in the position of potentially running afloat. And the question here was, did the master operate? Did the master make the decision and the calculations and the process reasonably? Did it go through this process to establish, was there a safety concern here? And ultimately, the decision was yes. That the master did make a sound decision on that, and as I said before, the consultation with the owners was critical to this, that there was a policy, it was talked about, the policy was followed, it was reasonable to follow the policy. So when you then pull that within those provisions, you can see why it went against charterers.
And I think what the charters were trying to argue was that there was a kind of plan put together that would have allowed the vessel to have, even if it was under the UKC, then it would only have been under for a very small period of time, and it would have been safe, and they could have given a waiver. And I think from the charter's perspective, there is some argument to say, the berth has an advertised depth, and we're not at that depth. And on top of that, we've also got some tide, and on top of that, we're also discharging. And as we discharge, we are going to have more room. So I can kind of see why charters were a bit frustrated here. Their view will have been, there was actually space at this berth, and I mean, you could have gone into it. But obviously that analysis doesn't take you very far when you look at the need for a bit of extra room, the 10% threshold. And particularly, I think what really killed them a little bit in this case was that they tried to berth the first time. They were told that the discharge rate was actually much lower than they expected it to be. And the master had very clearly expressed concerns, and in witness evidence, this point seemed to be made very well, and it seemed to land with the judge. That why would it be any different the next day? I've come in on the promise of a quick discharge, and you've told me that it's going to take longer. And then tomorrow you're asking me to come back, and you're saying, "Don't worry, we'll do it at 10,000 barrels an hour." Why would you suddenly be able to do it faster than you were able to do it yesterday? That seemed to weigh in its decision. Yeah, exactly. What's changed?
And I don't think they really got a straight answer on that question either. When they did ask what's changed, there wasn't really a clear reason for the change in discharge rate.
And I think you're right. I think you're right, Callum and Lucy, in that did sway the judge. I think that was a relevant factor in the mix. There wasn't any compelling evidence as to what had changed. Had they done something? Had they rearranged things ashore? Where it's in this discretionary kind of realm where the master's trying to make a decision, taking into account many factors, that being one of them.
just going back to one of those points that we spoke about before, what I thought was really interesting here is that they didn't give charterers any benefit of hindsight here. It was the information that the master knew at the time based on the information they had. And I think that's why this kind of change between discharge rates was so relevant at the time, because that was the information or contemporaneous evidence at the time. That's all he had to go off. And it's one thing to sit back with the benefit of hindsight and say, oh, yes, it was safe, but charterers aren't given that benefit here.
I wasn't certain exactly how that played with the contract, but my kind of reading between the lines on it is that clause 3.2, which says owners shall adhere to charterer's voyage instructions as long as such orders are considered safe by the master of the ship. That was kind of taken to mean that ultimately, as long as the master is exercising this kind of safety refusal for genuine reasons that were in his mind at the time and were reasonably founded, then that's enough. And the one thing I perhaps would have liked from this judgment is a slightly clearer expression of how the judge was reading clause 3.2, and perhaps it was just too obvious to need to be said. But I think that was probably how it was coming across, which is why hindsight didn't then play into the decision.
Yeah, it's interesting. We're having done a number of these with you, Calum, and Lucy before.
Number two.
Number two, yeah, exactly. How different it is reading decision of first instance versus an appellant decision, where the judge's role is very much a fact finder, of course, applying the law, and you will at first instance also get quite analytical judgments as well. I'm not suggesting that we don't see them, but it is marked that a decision like this is very much coming to a conclusion on what the judge thinks is the right factual decision applying the law. And whereas in the appellant decisions, it's much more about the law, obviously, and there's a lot of analysis in those decisions. I don't, as you were describing that, I thought, yeah, I did. That didn't jump out at me when I first read it because it's a decision of first instance. If that makes any sense. Yeah,
exactly. It's a very good point, and I don't know if it's also a feature of this kind of shorter trial scheme, but it was a very easily readable decision, and the judgment, I think the judgment runs to about 9 pages, including the front sheet. So it's a very well condensed summation of all the different facts on a pretty complex factual case. I can imagine a case with all these different facts running to a sort of 20-30 page judgment in other circumstances, and I wonder if that is just part of this kind of shorter trial scheme. You get a punchier decision, just with all the real salient facts.
Yeah, that may well be the case. Did we have any other comments on this part of the judgment, or should we jump over to the free pratique aspect of it? Let's get into it. All right, Lucy, what's going on here? What are we talking about?
This was quite a technical argument, I think, that charterers tried to run to try and get out of their liability for paying demurrage for the delays. And so essentially the argument was that on the terms of the charter party, if free pratique isn't granted before the notice of readiness is tendered or within 6 hours after the notice of readiness is tendered, then lay time and demurrage doesn't run effectively. So the NOR is invalid. And in this case, free pratique wasn't expressly granted. I think I've got that right. They don't have any record of the terminal actually, or the port actually saying, yes, you're okay to come in, free pratique is granted. But I guess the argument was that they acted at all times as if free pratique had been granted. And so there was never the vessel was never prevented from coming in because of it, but there was just no express sign-off, which I think was quite an interesting argument in this case to try and stop the valid tendering of the notice of readiness on this basis.
I kind of have sympathy with this argument. If the NOR requires free pratique and there is no evidence of free pratique being granted. I mean, there's no kind of express documentary evidence of it being granted as it transpired. There was significant evidence that it had been granted because everything was happening as though it had been. but worth a shot to run an argument saying that the NOR requirements should be strictly applied.
I thought this. I'm a bit with you on this, Lucy. I thought it was a neat little argument and quite technical. And the judge kind of looked at it in two ways. There was the formal question, if you like, of whether it was customary to grant free critique. And then secondly, there was this question of the mechanism of the grant. And how it, basically the authorities here proceeded or acted as though free critique had been granted, and so it kind of got into it. This wasn't a main part of the judgment at all, but it is interesting because we do see this type of issue come up. It's the kind of client picks up the phone and say, I've got a ship, got an NOR issue. What do you think? I don't want legal advice on it. Just tell me your thoughts in 10 words or less type question. And we get those kinds of questions all the time, as you guys know. But this is the type of question that falls into that category. And you can, I think, looking at the key paragraph or two on this is quite instructive. I found. I thought, okay, this is a neat way of looking at it.
Yeah, I agree, because what you have here is a situation where what's actually happening doesn't marry up with what documents the charter requires, and this is all dealt with pretty quickly by the judge, and very sensibly, I would say. Basically, the judge says it looks as though free critique has been granted, and either there was no formal mechanism for the grant of free critique, or alternatively, there was just a system of free critique by default. But either way, that doesn't, there's no free critique issue here preventing the NOR from being valid. It's not like you had to go and do something, you weren't allowed to berth, and the ship wasn't ready, and therefore you have you don't get the NOR validity. It basically, everyone was proceeding on the basis that free critique was granted, and there's no reason to say the NOR was invalid just because there wasn't a document saying here is our documentary evidence of free critique being granted.
But I think that's still an interesting conclusion to come to when the clause does say you need free critique to be granted before NOR can run. And I think that going kind of those cases that Luke was talking about, when you're checking like the shopping list of when time is to start, free critique is always one of the things to check. To see if time has even started. So to have a judgment here which kind of confirms that might not always be the case is quite interesting.
It is, and I think this is actually quite helpful to owners in general, because there is that situation where you need something on the shopping list that you can't get, and this kind of says, well, okay, we can be a little bit practical about that.
Or something on the shopping list that you don't ordinarily get, because I think that the importance or I don't know, I feel like it's kind of faded away a little bit, which is clear from this decision, and that it wasn't given out by the port, and that's not really in owner's control. So
then the kind of conclusion of the case ultimately was the master was acting reasonably, genuine concerns, and therefore the claim for demurrage was a good one. Demurrage continued to run. There was no reason to stop demurrage because owners hadn't done anything wrong. There was no fault on owner's side.
Yeah, and all the lightering costs fell on charterers.
Yeah.
So the counterclaim. So charterers, I don't know if we mentioned this at the start. Sorry, I can't remember. But the charterers had a counterclaim for lightering, all the costs related to lightering if they were to get up, and if this was ultimately viewed as had owners operated unreasonably or not within the contract and they were in breach, then it was agreed that the counterclaim would win out and they'd recover the lightering costs, and it wouldn't have had to pay demurrage. But that's not what transpired. So, yeah, and this argument around the half rate was also tossed as well, as we kind of alluded to earlier, that this wasn't a situation where it was just outside of the control of anyone. This was a situation where the vessel was asked to call it a berth, where it wouldn't always remain afloat, even if there was some uncertainty as to whether it would touch bottom or not. We're talking about a range or a tolerance in there, and in those situations, the analysis is not so much about would the vessel have touched bottom or not. it's not a black and white question like that. It's more about the process. Was the policy reasonable? Was it applied properly? Did it form part of the contract? Was there dialogue, communication, and was the decision ultimately a reasonable one?
And I think beyond that were the orders of charterers orders where they had undertaken proper due diligence to make sure that the berth was safe. And the judge says, I don't need to make a finding on that obligation, but if I was to, then I would find that you hadn't exercised due diligence. So in that situation, I think when charters then try and argue it should only be half rate because this was really outside everyone's hands, the judge is saying, no, it was pretty firmly in your hands to exercise due diligence on the berth, and you didn't. The master did, and the master found it was unsafe. So tough luck, full demurrage.
Great. Well, look, Lucy, you're welcome back anytime to talk about free pratique, to talk about UKC policies, to talk about demurrage. No, look, we're happy to talk about other things too, Lucy. It's always a pleasure having you on.
Demurrage only. No, they happen pretty frequently, so I might have to share that around.
Yeah, I was going to say, we can't be too far away from the Eternal Bliss Supreme Court case. I don't know when that's going to happen, but it can. I think that should be at some point in the not too distant future. So that'll be a demurrage case to get you back for. Very
much looking forward to that. I'm looking forward to that decision. Although there may be a bit of a battle as to who gets on to talk about the Eternal Bliss, because I know it's a favourite of many in the firm. Great. Okay. Well, look, thank you, listeners, for staying with us till the end. We hope you've enjoyed the discussion today. I know I very much did, and it's great to have you on, Lucy. Always good, Calum, to catch up and talk about the latest shipping case or commercial case or what have you case that comes our way. We've got some really exciting guests coming up, I will say. A little plug. I won't yet reveal names, but we've got some external guests coming onto the podcast in the coming weeks. So keep an eye out. And as you will see, and not just hear, we are now putting this podcast out on YouTube with some video. It's still early days in our videoing of podcasts, so please do forgive any kind of, looking in the wrong direction type stuff. But it's all fun and games. Thanks for staying with us, and we're grateful that you listen in. Okay, take care.